computer's having a work slowdown, so hang on.
Okay. Actually, it's funny because we have AP exams today for kids to get college credit, and my sister's daughter just came over here because her power went out. I mean, it's crazy. You know what I mean? Because everything, they're doing their online exams. You can't get online and do her exam.
Oh, great time to have your power go out.
Exactly. Well, she came over my house. Lucky I still have power. Let's just cross my fingers it doesn't go out.
Okay, for some reason this terminated and I had to start over, but I've just done, 4 or 5 hearings with no problem.
Well, maybe the weather. I don't know because it was a lot of rain.
Okay, let me try it again and start all over from the beginning. I don't know what, oh, it does appear to be on. Okay, I guess we are live. I was having a little trouble with my computer, but this is People of the State of Michigan versus John Wesley Thomas Jr. Okay, docket number 18-962FH, and this is the time set for hearing on the defendant's motion to withdraw his plea and/or motion for a Ginther hearing and/or to correct invalid sentence. May I have appearances for the record, please?
Tracy Gittleman for Mr. Thomas today.
Kayla Crino for the people.
All right, go ahead, Ms. Gittleman.
Okay, this is our motion, as you've already stated, to withdraw at all. With regard to the motion to withdraw plea, the prosecutor really did a great job briefing law. Can you guys hear me? Because it did something. Let me see here. Oh, I see. Okay. So I'm not going to go into the law because I think they did a great job. The only thing I do want to point out, I did cite this People versus Smith case. And I've worked with that case before on a few other withdrawal pleas. And the only difference between that case and this case, which doesn't help my client's point of view, is that that did involve a Cobb agreement. And I do want to point that out to the court, that there was a Cobb agreement for sentencing to the low end of the guidelines. Now, in
Wait
this
a minute, wait. On this case, you're saying there was?
No, I'm saying the case that I cited in my brief, People versus Smith, the difference really between that case and this case is that there was a Cobb agreement, sentence agreement in that case. We don't have a Cobb agreement in this case.
Okay, I'm looking at your motion in your brief, and on page 2, paragraph number 4, you say, the trial court at the plea indicated at the plea taking that the 25-year mandatory minimum would be dismissed and Mr. Thomas would be sentenced at the low end of the guidelines, and you go on to characterize that as a Cobb's agreement.
Well, that was my next point, because I wanted to argue both, which is that there was certainly a Cobb agreement in the Smith case, but here the problem with it is that it was ambiguous as to a Cobb agreement or not. The ambiguity here is that it was mentioned on page 10 of the plea transcript that he would be sentenced at the low end. But I do note in the plea transcript, there was never any formal statement by the prosecutor or the court that there was a Cobb agreement.
Ms. Gittleman, I'm looking at page 10 of the transcript.
Yep.
Do you need to tell me, as an officer of this court, that you see there on page 10 that there was a Cobb's agreement to the low end of the guidelines in any way, shape, or form?
I just said that the court never said there was a quote unquote Cobb's agreement. That's what I just said. What I'm saying is that there is ambiguity in the plea process, because what it does say at page 10, line 13, is quote, on the low end of the sentence, end quote. Now, perhaps the court meant, reading this, that because the 25-year mandatory minimum would be dismissed, that we would be on the low end. But the way that Mr. Thomas took it was that it would be on the low end of the guidelines. I am not saying that there was anything on the record specifically stating Cobb agreement to low end. It doesn't say that on this transcript, but our argument is that Mr. Thomas understood that to be the case and also was promised by his attorney that he would be sentenced on the low end of the guidelines, which is supported by his affidavit, which with Ginther hearings, we always as appellate attorneys have to provide an offer of proof. And the offer of proof is the signed, handwritten affidavit by my client indicating what he understood was that he would be sentenced on the low end of the guidelines and promised by his attorney. So I was just pointing out that the case that I cited is factually different because that case, People versus Smith, which is a 2017 published case, does involve a Cobb agreement on the record. I'm not saying that this record specifically supports a Cobb agreement. I am not saying that. I am saying that there is ambiguity that my client understood it differently. And that case, that People versus Smith case, is interesting because it does talk about ambiguity on the record, that if there's ambiguity with regard to plea taking, that can trigger a Ginther hearing and or withdrawal of plea, depending on the way that the trial attorney testifies and or other facts. And that's really all I have to say about that issue, unless the court has more questions for me on that issue.
Not on that issue.
Okay. And then the second issues are the PRVs. And I went through these again after reviewing the prosecutor's response. And I still stand by what I wrote, which is on PRV 2, I only saw 6 and 7 to be counted, not what the prosecutor had, which was 2, 4, and 5. Those are all extremely old, well beyond the 10 years of even a discharge date. The prosecutor is correct that you don't look at the date of sentence, you look at the date of either discharge, end of parole, end of probation. So
that's not what the prosecutor's saying. That's not what the prosecutor's saying. You cited to MCL 777.50, and you claim in your brief on page 3 that that statute says the prior conviction's discharge date must have occurred 10 years prior to this offense date, July 5, 2017. Did you read that statute?
I see. I did read it. 770.50, you mean? 50.
Yes,
correct?
777.50.
Correct.
And do you think that's an accurate quote of what that statute says?
It's got to be within 10, the discharge date has to be within 10 years of the offense date, correct?
No, that's not what it says.
Well,
It has to be within 10 years of the next offense resulting in a conviction. The next offense resulting in a conviction. It does not say what you quoted it to say.
What do I hear? Oh, they're printing. Wait a minute, they're printing here. Just 1 second, Judge. Someone's printing and I won't be able to hear anything. Let me look at this again because in the defendant's commission of the next offense resulting in a conviction.
All right, I know your argument. Go ahead.
I've always used the 10-year gap rule as, and maybe I'm misunderstanding it, but the 10-year gap rule as that if there's 10 years between the offense date and the date of discharge, that isn't counted. But maybe I'm reading it wrong, to tell you the truth. Let's see.
All right, thank you. Ms. Carino?
Okay.
Thank you, Your Honor. I guess I'll address the motion for resentencing first. Does the court have any questions for me? Okay, thank you. So moving on to the reasons cited, motion to withdraw plea. Thank you. The defendant here has not alleged that there was a procedural error in the plea pursuant to MCR 6.310. Essentially, what he's trying to do is show this court that there's a fair and just reason to withdraw the plea. And in support of that, he offers up 3 reasons. The court has already very adequately addressed the first reason, and that is the allegation that this court somehow promised a sentence at the low end of the defendant's guidelines. And that simply isn't what the court said. The court's words were, the plea bargain is what the prosecutor said she is taking away. She is dismissing the part of this charge that would require 25 years on the sentence on the low end of the sentence. So this is in no way, shape, or form a promise by this court to sentence the defendant to the low end of the guidelines. Further, the defendant's plea hearing hadn't even begun at that point. After the court provided those advisements to the defendant, he took a moment, talked to his attorney, came back on the record, indicated for the court that he wanted to accept the prosecutor's plea agreement. And at that point, the court began complying with MCR 6.310. The prosecutor said what the plea agreement was. The defendant had an opportunity to ask questions. The court answered those questions, and the defendant made it very, very clear that he understood that the plea and sentence agreement that he was receiving was nothing more, nothing less than what the prosecutor said. Which takes us to the second allegation of error here, and that is that Mr. Woolley promised the defendant that he would receive a sentence at the low end of the guidelines. Regardless of whether this is true or not, the defendant made it clear he understood the offer that he was accepting, and he did that under oath. And the defendant has offered an affidavit that contradicts those statements that he made under oath, and he cannot do that. We look to what the sworn statements were, and it's clear when we do that that he understood the plea that he was accepting. The third reason, which hasn't really been addressed today in the oral argument, is the allegation that Mr. Woolley did not ask the defendant what his side of the story is, that he did not investigate, and that he did not review the evidence. I just want to briefly address that as well. One of the things that Mr. Woolley told this court was that they reviewed the video that very day, the same day as the plea, in order to make a decision about whether they wanted to accept the plea. So right off the bat, we can look at the transcript to see that that's not true. Second, even if some part of that allegation is true, the defendant doesn't offer up what Mr. Woolley would have found had he asked the defendant his side of the story. He doesn't offer us anything to help us determine how that would have impacted his decision to accept the plea, to not accept the plea. We don't even know what it is that he's saying happened. So this certainly is not something that would rise to the level of a fair and just reason to withdraw the plea. We don't even know what the defendant is talking about, is really the only way to put that. So if the court has any questions, that was the record that I wanted to make as to the motion to withdraw plea.
All right, thank you.
Thank you.
I do not need rebuttal time, so I'll proceed to rule on this motion. And first of all, the argument in the brief was that there was a Cobb's agreement that this court made for the defendant to be sentenced at the low end of the guidelines. Now, I know that there's also an affidavit signed by Mr. Thomas where he says he believed that, but the brief goes truly one step further and actually asserts that I made a Cobb's agreement to sentence the defendant at the low end of the guidelines. In argument today, the position is that there was ambiguity. If one bothered to read page 10 of the transcript in full, there is absolutely no ambiguity here. In answer to the defendant's question, I said the plea bargain is what the prosecutor just said that she's taking away. She's dismissing the part of this charge that would require 25 years on the sentence, on the low end of the sentence. She's doing away with that. That's the agreement. And then we proceeded, as the prosecutor said, to, once the defendant was satisfied that he understood, to take the plea. I can't even, in all generosity, call that an ambiguity about whether there was a Cobb's agreement. There was absolutely no Cobb's agreement. I explained it to the defendant accurately that the prosecutor was doing away with what would have been a 25-year mandatory minimum sentence. The defendant has said in his affidavit then that he believed he was being promised a sentence at the low end of the guidelines. There's absolutely no support for that in the record, but the defendant can't just file an affidavit saying he believes something different than what he said under oath he understood and believed and knew at the time of the plea. And I was very careful with him on this very, very serious case to make sure that he understood what he was pleading to and that he understood all the ramifications of it. And he assured me under oath that there was no other promise that was made to him, that he understood that even the guidelines that were estimated were not an agreement about his sentence. His attorney verified that as well. And all of that and more in the plea transcript directly contradicts the defendant's rather conclusory conclusion in his affidavit that he was promised he'd be sentenced at the low end of the guidelines. I do understand and see quite often that criminal defendants will say things like that completely contradict the record. I don't expect defense counsel to say something that completely factually contradicts the record. The other argument is that the defendant received ineffective assistance of counsel because the defense attorney never asked him his side of the story and the defense attorney failed to investigate. The record does reflect that the defense attorney did view the video with the defendant prior to the plea taking. And beyond that, the defendant has been completely nonspecific about what it was. Did he have some defense that was not investigated? Was there something about his side of the story that was pertinent and material to what happened here that should have been brought out? He makes none of these allegations. He just says it's ineffective assistance of counsel to fail to ask his side of the story or to fail to investigate. And none of that is supported. And then finally, there's the issue of the PRVs, PRV 2, 3, 4, and 5. Which counsel cites MCL 777.50. That is in fact the 10-year gap statute, so-called 10-year gap statute. And in that statute it says, in scoring prior record variables 1, 2, 5, do not use any conviction or juvenile adjudication that precedes a period of 10 or more years between the discharge date from a conviction or juvenile adjudication and the defendant's commission of the next offense resulting in a conviction or juvenile adjudication. Counsel cites that statute and miscites exactly what it says. It says between any two offenses there has to be 10 years or more, not between a prior offense and the sentencing offense. So that issue is also without merit. I have the PSI in front of me. There is absolutely no 10-year gap in the defendant's prior convictions, nothing even remotely close to a 10-year gap that would qualify under MCL 777.50. So for all of those reasons, I am denying the defendant's motion to withdraw his plea and or motion for a Ginther hearing and or to correct an allegedly invalid sentence. And Ms. Carino, do you want to prepare an order for that?
I can do that, thank you.
The only thing,
right.
Judge, that I would ask, and I'm going to reread that statute. I may have misread it. I'm going to look and make sure that I understand it because I don't know, I read things fast sometimes, but I did note that the prosecutor did say that PRV 5 should be scored at 15 versus 20. Can we just have that corrected? That was at her brief at page 21, 22. That doesn't change any score. I mean, that doesn't change any guidelines though.
Right, she does say that. We could have that corrected.
Okay, I appreciate it.
Thank you.
And then do you